Right. I think we've gone into this proceedings about 5 minutes now. So without wasting too much time or more time, we can start off the proceedings as it is. So, counsel, you can come in and enter in your appearance.
I'm sorry, my lord, my network is a little bit unsettled.
Okay.
My name is
yes, please.
My name is EW initials.
EW.
Yes, Ikpi. Ikpi is spelled IKPI.
IKPI.
Yes, my lord.
You appear for
the defendant, my lord.
For all the defendants? There are 5 defendants. Now, the case is Alhamdu H.S. Yakubu. Well, the suit number, first of all, is NIC JOS 29, 2019, between Alhamdu H.S. Yakubu and the government of the Federation of Nigeria through the Attorney General of the Federation. Yes, please.
Okay, my lord, I'm sorry. It was this morning I was just asked to take this judgment. I was not given a file. So I'll be grateful if the defendants are mentioned. That will enable me to know exactly who I'm announcing appearance.
That was what I was about doing. The first defendant is the government of the Federation of Nigeria. The second is the Attorney General of the Federation. The third is the Minister, Federal Ministry of Science and Technology. The fourth is the Federal Civil Service Commission. And the fifth is the Nigerian Institute of Leather and Science Technology.
My lord, is the third and the last.
The third and fifth.
Federal Ministry of Science and Technology.
The third and fifth defendants.
Fifth. Yes, my lord. I'm grateful, my lord. Yes, my lord.
All right. And the other defendants are absent. Claimant counsel is also absent. Well, the judgment is ready. There's no need to linger on. I'll go ahead and deliver the judgment. And where necessary, I will skip so that we can save more time and resources.
As the court pleases.
Thank you. You may mute your microphone. Judgment. After initially being heard by 2 predecessors in 2020, the case was commenced de novo before me on the 7th of June 2024. The summary of this case is that the claimant, a statutory employee appointed in April 2013 under the Federal Public Service Rules, was indefinitely suspended without pay in February 2018 after a disciplinary incident. He challenged the suspension for failure to comply with the rules, requirements for notice and affairs, did not effectively contest the evidence or cross-examine the claimant. The action commenced with the filing of a complaint on October 31, 2019. The complaint, expressly endorsed with a statement of facts and supported by all necessary ancillary documents, was duly served on the defendants. Pursuant to the leave of court granted on 10th May 2020, the claimant amended his statement of facts and also filed a reply and defense to the third and fifth defendant's statement of defense and counterclaim. Ultimately, the claimant's case rested on his amended statement of facts and witnesses' sworn deposition. sworn deposition, which were both filed on the 12th of May 2023. Again, with the court's leave granted on the 26th of September 2024, he amended his reply and defense to the third and the fifth defendant's statement of defense and counterclaim. The version he relied on was filed on 4th October 2023, together with the corresponding amended statement on oath. According to his pleadings, the claimant in paragraph 33 of the amended statement of facts filed on the 12th of May 2023 seeks the following reliefs. 1. A declaration that the purported invitation of the claimant mentioned in the letter of suspension dated the 27th of February 2018 was not proper, as a result of which same was incapable of being honored as per the time and place of the scheduled meeting. 2. A declaration that the suspension of a senior staff of the claimant's caliber for any period above 2 months is by the provisions of the relevant conditions of service and the Federal Public Service Rules 2008 edition improper, wrongful, unconstitutional, null, void, and ought to be set aside. 3. A declaration that the indefinite suspension without pay of a senior staff of the claimant's caliber for any period above 2 months is by the provisions of the relevant conditions of service and the Federal Public Service Rules 2008 edition improper, wrongful, unconstitutional, null, void, and ought to be set aside. 4. A declaration that the failure of the fourth and the fifth defendants to reinstate the claimant even after same was demanded, thereby giving them the opportunity to rethink their stand on the issue, to decide the matter one way or the other, thereby curtailing the indefiniteness of the suspension, is uncivil, unconstitutional, and same is tantamount to civilian and or executive lawlessness, being a complete sabotage of the rule of law. 5. A mandatory order compelling the first, second, third, fourth, and fifth defendants to reinstate the claimant back to his employment with full benefits. 6. A perpetual injunction restraining the defendants, their agents, servants, or privys, or anyone acting at their instance or instruction from disengaging the claimant as an employee of the fourth and fifth defendants, whether by way of suspension or otherwise, after reinstatement and until the attainment of the retirement age of 65 years and or upon putting in 35 years of service in line with the conditions of service and or the Federal Public Service Rules, except and unless in strict compliance with due process as well as the conditions of service. 7. A mandatory order compelling the defendants to apologize to the claimant publicly and in acceptable words, to be approved by the claimant and to be widely published through the national dailies at the cost and or expense of the defendants. 8. A consequential order mandating the defendants to pay the claimant the total sum of 5.8 million naira, representing all salaries, entitlements, and emoluments due to him from the time of the purported suspension, with effect from the 1st March 2018 up to July 2020, and thereafter at 202,640 naira, 10 kobo per month, up to the time of his reinstatement. 9. The sum of 732,000 naira, representing the unremitted pensions deductions made by the fifth defendant from the claimant's monthly salaries. 10. 6.6 million naira, representing liability claims as per unpaid vouchers and submitted claims in favor of the claimants. 11. 470,000 naira, the balance promotion arrears deliberately left unpaid by the fifth defendant to the claimant up to date. 12. 5 million naira exemplary and aggravated damages for the serious hardships and embarrassment caused and meted out to the claimant by the first to the fifth defendants. And finally, 13. The cost of this action. Notwithstanding that they were duly served with notices to appear, the defendants neither opened their case nor filed any final written addresses. By an application of the claimant's counsel, the court foreclosed the defendants from presenting a defense for their failure to prosecute it with due diligence, and accordingly, they were deemed to have rested on the claimant's case as of the 19th of June 2025. After the claimant's counsel filed and adopted a final written submission on the 20th of May 2025, the court reserved judgment to be delivered today. Now, I'll go straight to the decision part to enable us conclude this proceeding on time. You will get the judgment immediately after the proceedings today. Yes, this court's decision. For the determination of this matter, the court shall adopt and improve upon the issues raised by the claimant's counsel, to wit: 1, whether the relationship between the claimant and the defendants, particularly the third and fifth defendants, is governed by statutory provisions. 2, whether the suspension and treatment of the claimant violated the federal public service rules and the principles of fair hearing. 3, whether the claimant is entitled to the reliefs sought. On the first issue, which is whether the claimant's relationship with the defendants, particularly the third and the fifth, is governed by statutory provisions. Statutory employment describes contracts where an employee's role, rights, and duties are laid down by law, usually within the civil service or other government bodies. Such employment carries protections, entitlements, and obligations enshrined in legislation. So the contractual relationship is controlled by those specific statutory rules rather than by private contract law. To show that an employment contract carries a statutory character, 2 essential conditions must both be met. 1, the employer must be an entity established by legislation, and 2, the governing statute must contain clear, specific rules regulating the employment terms, especially disciplinary procedures applicable to employees in that category. It is beyond doubt that the relationship between the parties in this case is statutorily governed, since the claimant's employment falls under the public service rules. The next issue for determination is what a party alleging that his employment is statutory must establish. The claimant bears the burden of proving that his employment has a statutory character, not the defendant, and must also show that his suspension or dismissal was unlawful. It is enough to note that an employee alleging wrongful termination must rely on the terms of his service contract and demonstrate precisely how those terms were breached. He carries the burden of pleading and proving the contract, which is the foundation of his case. The employer, as defendant, is not obliged to prove that the dismissal was proper. The claimant supported his case with exhibits C1 and C4, which show that both his appointment and confirmation fell under the federal public service rules. Those letters themselves reference the FPSR, underscoring their mandatory effect, and his letter promotions under the same framework further confirm his statutory basis. In line with the Supreme Court's decision in Olorun Toba Oju versus Abdul Rahim, citation supplied, where it was held that the statutory appointed employee enjoys enhanced job security and cannot be removed except by strict observance of the enabling statutes procedures. Any disciplinary action against the claimant must adhere strictly to the federal public service rules. It is thus this court's holding to resolve issue 1 in favor of the claimant. Now, issue 2 asks whether the claimant's suspension and the manner of his treatment breach the federal public service rules and the principles of fair hearing. Having resolved issue 1, it is clear that the claimant's employment is statutory in nature and governed by legislation. By its judgment of the 20th of August 2025 in suit number NICN JOS 27-2018, that is Nicholas Dobsell versus Plateau State Government and others, this court held at paragraph 123 on page 39 that And I quote, because the public service rules build in several procedural safeguards before taking any punitive step short of summary dismissal, an officer must receive a written statement of the precise allegations against him and be given a genuine opportunity to answer them, either by submitting a written explanation or by appearing before the appropriate authority or tribunal. The officer also has the right to legal representation and to appeal any adverse finding through established internal channels, for example, the Public Service Commission, or to the governor without prejudice to his right to pursue judicial review. End of quote. The decision of the Court of Appeal in Nemasa versus Ode, citation supplies, reinforces this principle when it states inter alia that the civil service rules confers on a public servant a legal status that goes beyond that of an ordinary master and servant relationship, etc. Now, in this case, the court's records show that the fifth defendant imposed an indefinite suspension on the claimant without issuing any fresh query or holding a hearing, despite the fact that the earlier WhatsApp-related misconduct had already been dealt with through prior discipline. The claimant was only verbally and indirectly summoned on the same day management meeting in Zaria, a requirement he could not reasonably meet. He was then sent a suspension letter dated the 27th of February 2018, which he did not receive until the 6th of March 2018. These actions breached natural justice, notably the Aldi alteram partem principle. Under the Federal Public Service rules, any disciplinary action must be founded on a prima facie case and conducted both fairly and without undue delay. You may see the case of Obida Ibrahim Dakat versus FRSC and two others, unreported suit number NICN JOS /38 2023, judgment delivered on the 20th of August 2025. Now, under Rule 030307G of the FPSR, any disciplinary matter that is not wrapped up within 60 days must be reviewed. Rules 030403 and 030406 further mandate that a suspension be time-limited and justified by the public interest. By suspending the claimant without a hearing and ignoring these provisions, the fifth defendant's action is both procedurally and substantively flawed. As the Supreme Court held in Shita Bay versus Federal Civil Service Commission, citation supplied, disciplinary measures under a statutory regime must strictly observe all prescribed steps. Based on the foregoing analysis, this court finds that the claimant's suspension was illegal, procedurally flawed, and unconstitutional. I so hold. On the third and final issue, whether the claimant is entitled to the reliefs claimed, the claimant put forward a consistent case supported by oral testimony and 29 documentary exhibits, including appointments and confirmation letters, salary records, and unchallenged claims and vouchers. Although the defendants were represented by counsel, they neither cross-examined the claimant nor led any evidence in opposition. It is settled law that a party must prevail on the strength of his own case rather than the weakness of his opponents, a principle which is unaffected by the Supreme Court's decision in SPDCN Limited versus Edamuke, citation supplied, which confirms that uncontroverted evidence must be accepted. Similarly, in Agagu versus Miniko, citation supplied, the court held that pleadings not supported by evidence are deemed abandoned. When a court finds a disciplinary measure to be unlawful, the claimant's remedy is restitutive damages. If that measure led to a removal from office, he must be reinstated to his former position and paid all back pay from the date his employment was disrupted until his judicially ordered restoration / reinstatement. Now, respecting reinstatement, this court held in the case of Mr. Chijioke Chimezie Daniel versus Federal Road Safety Commission, citation supplied, and I quote, that reinstatement is not ordinarily the remedy for breach of contract of service, but exceptions to this include where the contract of employment has statutory flavor, end of quote. In Nigerian statutory employment disputes over unlawful termination, damages are normally calculated to reflect the employee's lost earnings, essentially the salary the employee would have received during a reasonable period spent seeking alternative work. In support of his claim, the claimant supplied detailed vouchers documenting the unpaid entitlements and salaries he was owed. None of these claims was contested by the defendants. Although they fall within the category of special damages, the court finds that the claimant's particulars credible and an accurate reflection of the back pay, salaries, and allowances owed to him for the entire period of his unlawful suspension. On the strength of the foregone, it is the decision of this court to grant the claimant's reliefs. Accordingly, I find the claimant has discharged the burden of proof and is entitled to the following reliefs. Reliefs granted are: 1, a declaration that the purported invitation of the claimant mentioned in the letter of suspension dated the 27th of February 2018 was not proper, as a result of which same was incapable of being honored as per the time and the place of the scheduled meeting. 2, a declaration that the suspension of a senior staff of the claimant's caliber for any period above 2 months is by the provisions of the relevant conditions of service and the Federal Public Service Rules 2008 edition improper, wrongful, unconstitutional, null, void, and is hereby set aside. 3, a declaration that the indefinite suspension without pay of a senior staff of the claimant's caliber for any period above 2 months is by the provisions of the relevant conditions of service and the Federal Public Service Rules 2008 edition improper, wrongful, unconstitutional, null, and void, and it's hereby set aside. 4, a declaration that the failure of the fourth and the fifth defendants to reinstate the claimant even after same was demanded, thereby giving them the opportunity to rethink their stand on the issue to decide the matter one way or the other, thereby curtailing the indefiniteness of the suspension, is uncivil, unconstitutional, and same is tantamount to civilian and or executive lawlessness, being a complete sabotage of the rule of law. 5, a mandatory order compelling the first to the fifth defendants to reinstate the claimant back to his employment with full benefits within 14 days of this judgment. 6, a perpetual injunction reinstating the defendants, their agents, servants, etc., from disengaging the claimant as an employee of the fourth and the fifth defendants after reinstatement and until the attainment of the retirement age of 65 years and or upon putting in 35 years of service in line with the conditions of service and or the Federal Public Service Rules, except and unless in strict compliance with due process as well as the conditions of service. 7, an order mandating the defendants to pay the claimant the total sum of 5.8 million naira, representing all salaries and emoluments and entitlements and emoluments due to him from the time of the purported suspension with effect from 1st March 2018 up to July 2020. 8, the sum of 732,000 naira, representing the unremitted pensions deductions made by the fifth defendant from the claimant's monthly salaries. 6.6 million naira representing liability claims as per unpaid vouchers and submitted claims in favor of the claimant in respect of costs and expenses undertaken by the claimant for and on behalf of the fifth defendant. 10, 470,000 naira, the balance promotion arrears deliberately left unpaid by the fifth defendant to the claimant to date. 9, the cost of the action assessed at 1 million naira only. And 12, consequentially, all monetary awards shall be paid by the defendants either jointly and or severally within 30 days of this judgment, in default of which the entire sum shall attract 5% interest per month until full liquidation. Is counsel still online?
Yes, my lord.
Sorry, I had a technical hitch.
It's okay, my lord.
Only went off. I don't know why. But I was just about rounding up when it did, so I had to use a different device now. So please,
It's okay, my lord.
thanks for that. Yes, I was on the last details of the judgment. Please, I'll repeat the last aspect before concluding this proceeding.
As the court pleases.
The 12th relief which is granted is that consequentially all monetary awards shall be paid by the defendants either jointly and or severally within 30 days of this judgment, in default of which the entire sums shall attract 5% interest per month until full liquidation. Finally, judgment is entered accordingly, and that is the order of this court.
As the
Counsel?
court pleases.
Yes, please.
Yes, my lord.
Like I
I
said,
want to appreciate my lord for the judgment.
I also appreciate your joining in at a short notice. I understand the NBA conference is on right now. I'm sure it must have beaten into your time. But I wish you all the
Yes,
best as well.
thank you, my lord.
A copy of the judgment shall be online within the next 30 minutes from now, and then you will get soft copies of it immediately after proceedings today.
Very well, my lord.
Thank you. I wish you all the best.
Thank you. Thank you, my lord.